recording, and if you guys have your video cameras on, that's great. But
yeah, we are recording this session. If you need to go to the restroom, please make sure to mute yourself and take the video off, because that would just not be good for anybody. Okay, welcome to this mock closing. These are always fun. A great partner of the office, Oak Title, is here. Stuart Pirri, the founder and lead attorney, as well as Blythe Thompson, who is their marketing client relations specialist. No, I'm just making up specialist. There you go. She's the person to go to get your file started, is my understanding, right? All right. So what I want to start off talking about is the relationship between Oak and Keller Williams New Orleans. And the reason it's special is because when I reached out right when COVID was getting started and proposed this kind of electronic payment scheme that we've been working on, Stuart was the first one to latch onto it and take action. So here's what we're doing. We want to make it as easy as possible for money and paperwork to just change hands. And even though COVID might be coming to a close, fingers crossed, I don't think business is going to go backwards. And plus, I hate paper checks. They're a real pain in the butt. So if you do a closing at Oak Title, what they will do, and correct me if I'm wrong, Stuart, what they will do is they will electronically send your commission check and your cash sale document to you via email and Holly. Okay. Well, they're going to send the money to us, to our account, and they have a special account just to make this happen. And so do we. So we receive it. Holly gets it. You fill out your compliance stuff, so you don't even have to stop at the office. And then we are going to ACH you that day, same day, if you got your compliance in before 4, same day, and you'll have your money in your account first thing in the morning, 90-something% of the time. So we've really tried to shorten and tighten this process up, and I think it's a really great opportunity for anybody. And, I've talked to other closing title companies, and Stuart's really been the only one that's latched onto it and figured out how to do it in a safe, secure way for everyone. And so I really appreciate that. And I think it'll make life easier for you as well. Okay. Well, without any further things to say, I'll introduce Stuart. Or Blythe, do you want to talk, or do you just want to go straight to Stuart? Okay, great. Let's switch to a Stuart height camera and go from there. Welcome, Lauren. All right, Stuart. Now everyone's going to see the top of my head now. There we go. Take it away.
All right. Hello, everyone. As Jeff already introduced me, my name is Stuart Pirri. I'm the attorney and founder of Oak Title. We just moved offices. We're not too far from you guys. We're on 7933 Maple Street, right down the street from y'all. And today, Adam got with us, and it's a class we've done in the past here with, newer agents or just some agents who want a refresher. And it's we call it a mock closing, but it's more than that. We also give tips to agents on how to make their closing go more smooth. And that way we're not scrambling at the last minute. I printed out some materials. I'm going to email them over to Adam today, just so y'all can have a copy of everything. And, he'll upload that to Facebook.
Yeah, we'll put it on there. And I also have the Elmo set up. So as you're going through, okay, I'll be showing them what you're talking about.
All right, well, perfect then. So Adam's gonna kind of go through the documents. So he's going to be able to project them on the screen. And he'll upload a PDF version of everything for you guys as well. So we'll just go ahead and get started. Whenever we do the mock closings, I try to tell people that your closing doesn't begin the day of closing at the table. It really begins when you sign the contract. These purchase agreements are legal binding contracts. A breach of a contract has legal consequences on the breaching party. And new agents, sometimes just not even new agents, some agents just get in the habit of, we'll sign it, we'll put in an offer. We'll say it's all cash, and then we'll switch it over to finance anyway, but we'll put all cash to make it, seem more attractive. Well, technically that is a breach of a contract. And so you just really want to read through these things, go over it with your client before you submit an offer, and make sure they understand the consequences of everything. So my first tip that I can give you, as soon as you have an executed contract, send it over to the title company immediately. A lot of times we'll get calls from agents saying, hey, we're going to use you on a closing. Really excited. Here's the purchase price. Here's in Orleans Parish. Here's the address. Great. Okay, send us over the contract. We don't hear anything. 2 weeks go by. We still don't have the contract. And it really slows down what we do, and it can maybe push back your close date. So the first thing you always want to do is send over that contract, and make sure the title company receives the contract so we can start, the process on our end. Here's some things that are going to affect the closing, the day of the closing, that you will put in the contract. Obviously, the closing date, that determines when we're all coming to the table. The inspection period, believe it or not, is very important to your closing date, because if you go through inspections, you see that something needs to be fixed, or you'll need to negotiate escrow or seller credit. All of this stuff is important to the closing and the final numbers that you'll see at the closing table. Obviously, the earnest money deposit, who's holding it, the title company needs to know that. If the title company's holding that, let them know so they can reach out to the buyer and collect it. This also affects the final numbers at the closing table. And you want to remember all of this stuff that I'm going over at the closing table, because you're going to want to check it on the final settlement statement. You're going to check it in the act of sale. So all of this, I know we're not at the closing yet, but this all ties into the closing. Another important thing, let the title company know if it's an all cash or finance sale.
Stuart, can I ask a question about the deposit?
Sure.
So if I have a client that is buying a property, they write their check for $5,000. How long do you guys hold that before you cash it?
Okay, so good question. We'll try to cash it same day. Sometimes that's not always possible. Sometimes we'll get a check at 4:00 in the afternoon. We already did our bank run that day, and it's a Friday, so we might not deposit it until Monday. However, it is important to know the money is still quote unquote hard once we receive the deposit. We'll make a copy of that check. We'll send it to all the parties to let them know that we've received it. I believe, is it 72 hours in the purchase agreement, give or take? It usually says within 72 hours of signing. We'll try to deposit that immediately. Another reason being, if it's a finance sale, your lender's going to want to source that deposit. They need to confirm that the deposit was received. If we just hold on to that deposit, it might not actually go towards their closing costs at the time of closing. So make sure, that's a great question. Whatever title company you're using, a lot of people just ask for a copy of the check. I always recommend ask for a copy of it showing that it's been deposited. So, we'll usually print out our little, the scan that the bank does with the back stamped showing that it was received by Whitney Bank or Home Bank or whichever escrow account we use, and we'll send that over as well. Another thing that's important to the day of the closing is home warranties. Usually the home warranty is a negotiating tactic that it's usually the seller will pay for it, to help, the buyer will ask for a $600 home warranty. That's important because I can't tell you how many times that it's not mentioned in the purchase agreement. It might be mentioned in an addendum. We don't receive that addendum. And then at the closing, agents are looking over and they're saying, well, where's the home warranty? I don't see it on the closing disclosure. So if you negotiate a home warranty, just point that out as well. And then the last couple things, seller credits are obviously important. You're going to want your buyer to make sure that they're credited for any seller credits giving or closing costs at the closing. And then as is, is it as is sale, or is it new construction, or is it a warranty sale? This is where you'll see the actual act of sale. And if it's as is, you just want to make sure that that waiver of redhibition and the as is language is included in that sale. Yes, Adam?
If a buyer is paying for a home warranty, can they just put that on the settlement statement and and just close, not have to come out of pocket?
Yeah, absolutely. So Adam was just asking if the buyer is going to pay for the home warranty, if they could just put that on the settlement statement. Yeah, absolutely. Can definitely do that. And then, so the as is new construction, if it's new construction, your buyer is awarded some protections. Your first year, you get certain protections in the house. I think your foundation is warranted for up to 5 years. Electrical and plumbing might be 2 or 3 years. And you just want to make sure if it is a new construction that you've agreed in that purchase agreement that at the closing table, you want to look in that act of sale and make sure they didn't put in the as is language, they're putting in the new construction language. So all these things are written out in the contract that you send over to the title company. A good title company will read through this, make notes in their file, and start making preparations. But even a good title company might miss some things. A bad title company isn't even going to look at the purchase agreement. And so it's really kind of up to you guys to, when you get that settlement statement and when you sit down at the closing table, to look over these things and make sure everything's accounted for. Tip number 2 that I have regarding the purchase agreement and leading up to the actual closing is anything signed after the initial purchase agreement. Inspection response, addendums, price changes, seller credits, send that over to the title company. Even if you think the title company doesn't need it, they decide to negotiate, well, we want to keep all the TVs in the house, and that has nothing to do with title, still send that over to it. The worst thing that you'll get from us is just a thank you for the update, and we'll file it away and not really worry about it. But there's a lot of times with, we never got an addendum, and the lender's never got an addendum on a seller credit, and we're sending out settlement statements 3 days before closing, and we're getting a call from Adam saying, hey, my client has $5,000 seller credit. Not saying that you wouldn't update us, Adam, just using you as an example. Where is it? And that can cause issues, especially if it's a finance sale, because lenders have to follow certain regulations depending on the loan, on how much they can actually apply that seller credit. All right, so we'll move on to the next page. Before closing, you'll receive a settlement statement, and I have a copy of a settlement statement in the package that I have, and I'll make sure again that it's uploaded. And the settlement statement will break down everything: the loan, the deposit, the purchase price, seller credits, and then of course closing fees. And before and you want to make sure that the closing fees resemble what you were told they were before closing. And this is a lot of times we'll get into this, newer agents especially kind of just look at the settlement statement. They say, let's see, oh my God, $20,000 in commission, I'm rich, and don't look at anything else. They don't see that, the title company or the bank or someone has a $1,500 fee that was never disclosed to you prior to getting, you got the quote and the number was 4,000 and all of a sudden title fees are 5,500. That's a huge discrepancy. And, the reason why you probably went with that title company was personal relationships and also making it work with your client and, with their money. So I always recommend asking for a quote, even if you know for sure, hey, I'm using Oak Title. We're going to use Oak Title. I want to call Stuart on the phone. I'll say, hey, can you send me over, just the estimated fees for this closing, just so I can let my buyer know on the title side what the fees are going to be. That way there's no surprises at the closing table. And when we're telling them 2 days before closing, please bring a cashier's check or wire us X amount of dollars, they're not saying what the hell. And also most title companies, if you really want to work with a title company and, their fees come in a little bit higher than what your client can afford, you can just call that title company and say, hey, kind of work with us here. Most title companies will be pretty lenient in helping you guys out. When requesting multiple quotes from title companies, I always try to tell agents, be careful. Not all quotes are created equal. Title insurance, I always recommend buying owner's title insurance. I can tell y'all tens and tens of stories about people who didn't buy it, or they did buy it and there was an issue and thank God they bought it. And it really helped them out. We're actually doing a closing right now where we don't know if we'll be able to close because the previous title company missed a $35,000 tax lien on the property. And, thank God the lady bought title insurance and she has a valid claim and they're going to help her clean it up. but it's pushing the closing back by about 60 days. Yep.
When does the client purchase the title insurance?
At the closing. So the question was, when does the client purchase title insurance? It'll all be rolled in at the closing with the closing costs. They won't need to bring an extra check. That final number that we give you give your client for the cash to close, if it's a $400,000 house, and let's say it's all cash and their closing costs are $5,000, in that $5,000 includes the title insurance premium. So they don't have to pay anything extra. They just bring their money to close and it's tied in with their closing costs. Title insurance is also a one-time payment. So they're not making that. It's not like homeowners insurance where they're making it recurring every year. They pay it once and they're covered until they sell the property. But because owner's insurance is optional, some title companies will not include that on a quote. And that's majority of your closing costs from a title company is title insurance. So Oak Title might send you a quote and title company B sends you a quote, and title company B's quote is $1,500 less or $1,200 less. And you're saying, wow, I mean, you just can't beat this price. Check and make sure that they've included the homeowner's insurance on there for title insurance. You just want to make sure that, and if your client decides, well, I don't want title insurance, let Oak Title know or the other title company know, and they can adjust their quote without title insurance and send it over, and you get a better comparison of the actual quotes. Other things to be on the lookout for on a quote and your closing fees is, yes, if you represent the buyer, they will be responsible for recording fees. Recording fees are not technically title fees. We don't profit on them. So some title companies will not include them in a quote. And then all of a sudden you have the same issue where one quote looks $360 less than another quote. So just make sure that, you look for title insurance and you look for recording fees. When in doubt, if one quote just seems way too low, pick up the phone and call the other title company with the high quote and say, look, they're sending in a lower quote. Is there anything you can do? Or call the low quote company and say, hey, I just want to make sure recording is in there, title insurance is title owner's insurance is included in there, and try to get the best accurate number. Hold on to those quotes. Quotes do change. They are an estimate. At the bottom of our quote, we always say if there's any documents that need to be overnighted, we just pass that overnight fee along. So it's about $40 typically. And I'll say quotes typically can fluctuate by $100, give or take. Sometimes as high as $200, but that's pretty rare. If you see something 300 plus out of the ordinary, hold on, keep that quote that was sent to you, send it back to the title company when you get the closing fees and just say, hey, I'm just a little confused. You quoted us this and now we're substantially higher. And when in doubt, pick up the phone, ask us, and we're happy to help. We're a resource. So we're getting closer to the close date. We're getting closer for the actual closing, and just some things that the title company wants to know. I can tell you, if you come to the closing and you're either whether you're a listing agent or the buyer's agent, and this is the first time you'll look at the settlement statement, one, shame on the title company for not sending it out earlier. Two, if they did send it out earlier, shame on the agents for not looking at it. But they're looking at the settlement statement. They say, I don't see prorated rents or a deposit because there's a renter that's in this property. And, it's an investment property. It's not going to be used for their own home. So, that's the one thing that you can help with a title company is anything that's out of the ordinary, let them know on ahead of time. Is it a rental property? If yes, give the title company a copy of the lease. And the title company is going to ask you what the monthly rent is, when rents are paid and due, and also what is the deposit. All of that stuff needs to be taken care of at the closing. And this is important information that you're going to want to know as well to make sure when you get to the closing and you're looking at settlement statements that the title company has accounted for everything. Also let the title company know if if the person buying it is an LLC or a company or an organization, not just an individual. Yes, Adam?
If I'm getting a mortgage in my own name, can I close in an LLC?
So yes and no. So if it's more of a lender question. We have a lot of people who get them, mom might take out the mortgage and the kid is not on the loan, but the kid is going on title. He just didn't have the credit. So they make the loan be in mom's name. Both, it's as long as whoever's on title signs the mortgage, that's fine. So if that company's going, so your hypo was the property goes into the LLC's name, but you're taking out the loan. So you would sign the note and you would sign all the loan docs, but the LLC would sign the mortgage, acknowledging that there is a lien in your name on the property. But yeah, you just get with the lender to make sure they can do that. But it's not that uncommon for people who are not on title to take out a loan. Just everyone who is on title has to agree to it and sign it. But let the title company know if it is an LLC. If you are, and that's a great question, if you are planning on doing that. We have a lot of people who say, well, I'm buying it in my personal name, and then I'm just going to transfer or donate it to an LLC, or I'm going to buying it in my personal name. My wife can't be on title because the bank won't allow it, and I'm just going to donate it to her right after we do the closing. Let the title company know these things so they can kind of get a better sense of what's going on. And then also there's certain documents that need to be executed. And also, let the title company know as well, because that might affect your title insurance. If person A buys the property, only person A is insured. And then he's like, look, I'm just going to donate it to, B and C afterwards. B and C might not be covered on title. And that's why we want to know, so we can explain the risk to them in those situations, and we can better game plan for certain things. Let the title company know, you do a final walkthrough. Day of closing, you do your final walkthrough, and there's holes in the wall. There's, they took the TV mount out and didn't repatch or paint, and just say, look, this is $2,000. We need to hold an escrow. So what you'll do is you'll call the title company right after the walkthrough, say, hey, look, we're going to hold $2,000 in escrow. Give us the detailed terms of the escrow agreement. Every title company has an escrow agreement form. We'll fill it out specifically and tailor it to the situation, and then ask to see that before people sign it at the closing table. Make sure that, look, they're holding it for 2 weeks. Our standard form has 1 month, but some people like to do 2 weeks. So make sure you look and say, oh, no, you're holding it for too long. It should be 2 weeks. Or no, look, it's not just paint. They also need to sheetrock the wall. And so when you get to closing, that's if an escrow agreement is involved, that's one of the first things you should ask to look at, just to make sure everything looks good before anyone signs it. Worst thing you can happen is, the seller who obviously doesn't want to be an escrow signs it, the buyer signs it, and the seller just says, well, you already signed it and agreed to it. We have a contract. We're not changing the terms. And just some little things, if your clients are married, let the title company know. Louisiana is a community property state. So that does play a major role in what we do on the title side of things. Yes, Adam.
Does it matter if they were married or if they're currently married?
So both. So Adam asked, does it matter if they are currently married or if they were married? We want to know their marital history and their current marital status.
Why does that matter?
So again, community property state. A lot of people tell us, "Oh, I'm divorced." I'm single, divorced. We go look it up. Well, your divorce isn't final. No judgment has been rendered. Technically, you go to buy this property. Your soon-to-be ex-husband or wife is going to be on title, and that can cause a whole issue of things. It also just helps if your name is John Smith. There's a lot of John Smiths, and this John Smith happened to be married to, Becky Sue, whereas this John Smith was never married. So it kind of helps when we're pulling stuff and just say, oh, wow, there's a John Smith who has a, $5,000 judgment against him. Oh, but it looks like he's married and this one has never been married. And that's kind of why we ask for the marital history there. Mm-hmm.
So do you just look up the divorce decree in the state that they were divorced in?
Yes.
Okay.
Because again, Louisiana will govern where the property is located, governs the law. So the property is governed in Louisiana. So if you were married in Florida and you say you're divorced and you're really not divorced, but you buy property in Louisiana, Louisiana will say, well, you were technically married. We're actually going through a problem right now with a gentleman from Texas who said he was divorced. He bought the property. Now he's trying to sell it. And we're saying, oh, no, you weren't divorced. You bought it. We need your wife's signature. There's ways around it if you're not divorced to buy separate property. We can get creative again. You can do what's called double declaration, saying this is my own separate funds to use to buy this property, will remain my separate control and not be part of the community. That's generally what we do in that situation. But yeah, that is why we ask about marital history and marital status. And then finally, this is little, but it's little to most people, but it's very big for a title company. Adam, you're closing next week, correct?
Yeah, Wednesday.
Thank you. Adam's closing on a Wednesday. So most people close on Fridays.
No.
So what we have is next Friday, we have 11 closings on the books. So you can see that scheduling gets very tight. We are first come, first serve. So if the bank gives us the clear to close, we're going right to the parties who, as soon as we get the clear to close, to schedule. And if they say noon, they get noon. Yes, Adam.
I was gonna say the reason I'm closing on Wednesday is if we don't get a clear close or something happens or anything gets pushed, we're moving till Thursday. If it's on a Friday, not only does everybody else want to close on Friday, but if we miss one thing, we're not closing until maybe Tuesday.
Correct, because they have to redisclose. Yep.
And so, yeah, if they have to redisclose, then it's going to be Wednesday if they didn't get it out in time. So, yeah, I just want to be in the middle of the week just to keep it safe. So that way we can still close that week.
Right.
And we don't have to wait all those other weekends or even holidays. I mean, if it was last weekend,
right?
Yeah, you got that holiday.
So, and we selfishly prefer Tuesday, Wednesday closings because no one closes on Tuesday, Wednesdays. It's easier when we have 11 closings on a Friday, and closing number 11 finally gets the clear to close, and we say, look, here's your 2 time slots. You got a 8:30 and you got a 3 o'clock, and they say, well, I'm only available at 10 o'clock. It's kind of out of our hands. And so we always ask, let your clients know, look, on the closing date, go ahead and be flexible. If you're closing 30 days from now, give your boss that 30 days notice as well. Just be like, hey, look, just let you know, I'm closing on my new house October 1. We don't have a closing time yet, but I might have to just be flexible on that date and let them. Same with power of attorneys. It's amazing. We have a lot of people agree to be people's power of attorneys because the other person just can't come to closing because they don't have a flexible job or they're out of town. And the power of attorney says, well, I work 9 to 5, so I can only close either at 8 or 6. Well, banks aren't open at 8 or 6. It's kind of hard to close if we're expecting a wire and funding approval at 6 o'clock at night. We'll try to be as flexible as we can. We'll get creative. If seller can only close at 9 a.m. and buyer can only close at 1 p.m., we'll do a split closing. It's pretty common. But just, let your clients know, be flexible on the date of the closing.
What if the buyer lives in a different state and they don't want to be here for the closing?
So if the buyer lives in a different state or a seller and they don't want to be here for the closing, we can draft a power of attorney. Now, a power of attorney is going to cost them a little bit extra. So if it's going to cost them to record it, it's $100 extra to record that power of attorney. And it's going to cost them extra in drafting it. Any title, it's usually anywhere from $100 to $150, depending on the title company you're using. And then if we have to send, an overnight package for them to get it back in time for closing, they're going to be paying for those fees as well. The other option they can do is we can do mail away closings, whereas we will scan in the whole package, email it over to them, they'll print it out. We'll arrange for a notary to meet them at a certain place, usually a bank or an office building. And that notary will execute the closing, scan in the docs back to us, and then overnight the whole package right back to us. Again, usually we use a company called BankServe. I don't know if y'all have ever heard of them. They provide notaries nationwide. It's anywhere from like $140 to $300, just depending on where you are located. And then the overnight fees, again, to overnight a full package, it's going to be anywhere, depending where they are, anywhere from $40 to $60. So those are just kind of the ways to work around. If, it's probably cheaper than buying a plane ticket round trip and getting a hotel room for the night. But if they don't want to be in the state, or if they don't want to come to the closing, these are just some things we can do to work around that. Quick side note on that. If you agree to be your client's power of attorney, Adam's shaking his head no, just be prepared that the way you sign, it's going to take you, instead of a 45-minute closing, you'll probably be signing papers for an hour and 15 minutes. It's a pain. It is easier if the agent is the power of attorney, just because you guys are more flexible. Y'all are coming to the closing anyway. But if you sign up to be someone's power of attorney, just kind of be in the mental capacity that, okay, it's going to be a little bit longer, and your hand will be cramping afterwards. If the bank allows it, we have another attorney in our office. Usually myself or the other attorney will volunteer to be the power of attorney, but the bank has to approve for the title company to do that, because we have a vested interest. All right, so real quick, what should an agent do to help on the day of the closing, or before, or the 3 days out when you receive that settlement statement? I already mentioned the biggest mistake agents make when looking at settlement statements is going right over and checking for their commission and nothing else.
That second page, top line?
Page 5.
No, I was talking about like the commission.
Oh yeah. So Adam already knows it. Second page, top line, or, depending on what form they use, it could be the second page, bottom line. So either way, it's going to be there. But things you want to look to make sure the purchase price is correct, especially if y'all have negotiated and have an addendum changing the purchase price. Make sure that the deposit looks good. And if the deposit does not show up on a settlement statement, call the title company and just say, hey, the buyer paid $7,000 deposit. Where is it? And sometimes they'll just say, look, the bank couldn't source it, or they couldn't use these funds. They'll get the $7,000 back at closing, but that's why it's not on the purchase agreement.
I was just
going to say that's really important, because I've had some deals where we went back and forth probably 7 times. And if you just looked at the purchase agreement, everything looks fine. But then if you looked at the next counter, the next counter, the next counter, the next counter, you had to put that whole story together and then make sure that all the numbers were correct.
Yeah. And that's exactly, if you just look at the purchase agreement, again, that's why it's so important to send those addendums to the title company and make sure, and, put a read receipt on the email. I'm not going to be offended if you guys do that, just to make sure that we've received it. Because, the title company might just look at the purchase agreement and that's the only information they're going off of. They don't look at any other addendum, or they didn't receive an addendum. But that just goes back to, the very beginning. The closing starts before we get to the table. It goes with that contract and anything signed afterwards. Look to see if the seller credit is on there. If the seller credit, if y'all agreed for a $15,000 seller credit and only $11,000 is on there, call the lender, call the title company, see why. As I already mentioned, some loans only allow a certain amount to be allotted towards a seller credit. And so they might say, look, $15,000 was too high. $11,000 on this loan was the max. So that's what we were able to give them. I think this might be a question for James Fiddler here, but I think it's 3% on a conventional mortgage is 3% is what the seller can offer for a credit. So if you have a $400,000 purchase price, it's $12,000 for the seller credit. And then just make sure, the home, if you have a home warranty, if money is being held in escrow, just make sure these things are also reflected on the settlement statement. Another common mistake that agents make is they never tell their clients that a title company will be calling them. Let them know that just say, hey, Oak Title's going to be calling you. Please be available either by phone, or they might send an email. Let them know exactly what we're asking for. That's social security number, marital status, marital history, and our current mailing address. Half the time we'll call a buyer, especially a first-time home buyer, and it's someone they've never heard of. Hey, my name's Stuart from Oak Title. Okay, I don't know who Oak Title is. I don't know who Stuart is. What's your social security number and your mailing address, and what's your full legal name as reflected on a government issue ID? Okay, hang up. This is a scam. I wouldn't want to give that information over to anyone over the phone. I want to be comfortable with it. So just let your clients know. We'll be calling them, asking for this personal information. If they feel uncomfortable, they can always come in person and give it to us. A lot of times they can give us everything over the phone except the social, and day of closing, they can come and just say, all right, it is legit. Here's my social. And we have a great program that we just type in the social and the documents we need with it on. We'll never have the full social on there. It'll just be the last 4 digits. It auto populates on everything. Another thing is let your clients know what cash to close means. We get a lot of people asking if they can bring personal checks to closing. Cash to close means exactly what it sounds. It's cash, so certified funds, so cashier's check, a wire, money orders. I don't recommend it, but if they want to bring actual cash to closing, they can.
Do you guys take Bitcoin?
We do not, no. So
Asking for a friend.
no Bitcoin, but we've had people come in and bring $10,000 in actual cash. One, I don't want to leave my office carrying $10,000 in cash.
Well, there's forms you have to fill out.
Oh, there's a lot of forms that you do have to fill out if you bring actual cash. Two, I don't have a accounting machine in my office, so I want to make your client sit there while I count it out in front of him, in front of the agent as well, just so we're all in agreement that that money is there, that nothing is short, it's the exact amount. So it's just as easy for them to take that $10,000 and go to a bank and get a cashier's check.
So the client will have all the forms to know exactly how much money they need to bring to the table.
Yes. So in a cash sale, the question was the client will know have all the forms to know exactly how much money they need to bring to closing. If it's a cash sale, we're doing a cash sale that's closing October 5th. I already know what, if we close on October 5th, I already know that number. This far, I don't need to wait on the lender with any of their fees. Don't need to wait on any insurances, anything like that. It's just the settlement fees and the title insurance that's being paid in the recording. So, we let the person know yesterday, hey, this is the exact amount you're going to need to bring. Of course, if it changes through and after inspections or an addendum or anything, we'll update you and let you know. But if it's a cash closing, ask the title company as early as you can. Just say, hey, as soon as y'all have the final cash to close, can we know that number? Because some people, might not have 400,000 in one account. They might have to go and take some from this account and move some money around in order to get everything ready. And that could take a couple days. If it's a finance sale, if a bank is involved, we can give you an estimate on what we think it is, but we are waiting on the lender's fees as well, along with if the lender requires any sort of miscellaneous payoffs that need to be paid. But there is a law, there is TRID, which states that 3 banking days before the closing, the lender must disclose. So they'll have at least 3 banking days before the actual closing with a ballpark figure. Sometimes it's off. If it's off, it's usually, again, by a couple $100. It's not off by much. Very rarely do I see where the lender completely dropped the ball and was like, oh, shoot, I forgot the $4,000 homeowner's insurance that needs to be paid. It might happen.
That happened to me once.
There you go. So it happens, but it's rare. That's also a good time for you as the agent to look over everything and just be like, okay, I don't see homeowners insurance under prepaids. Let me call the lender to make sure that that's required. Adam, yeah.
Oh, I was going to just make it worse because that was before TRID.
Oh,
and it happened at the closing table, and it was like a $90,000 first-time home buyer, and it was $4,000 off.
Yeah, and
she had to call her mom crying.
Yeah, and for some people, $4,000 might just be, okay, let me run to the bank real quick. I'll get another cashier's check. But for most people, $4,000 is a world of money, and it'll kill the deal. It'll say, I had to move all this money around for the last 3 days to collect what it is. I don't have another $4,000 to scrape up out of thin air right now. I have to, go get a gift, or I have to go, call my bank, which is out of state. Please tell all of your clients, if they bank out of state, to call their bank early and let them know that they're closing. If they have to wire money, some banks say you have to be in person. Let them know what forms they need to fill out. We get a lot of people with banking out of state that goes, well, I can't get a cashier's check and I need to be in Chicago at the bank branch to actually wire it. What do we do? And it can, We actually did a closing with that exact situation. We had to have the guy write a personal check, open up account at the Whitney Bank, and wait 5 days for that check to clear, and then him come back with his new account and cashier's check from the Whitney. Yes.
Can I just get stacks of money orders from
The post
Circle
office?
K?
Oh yeah, that's fine. Money order, that's fine.
Okay. Or Venmo?
Venmo, no. But the one thing about money orders is I think they limit it at like $1,000.
500.
It's 500. So if your cash to close is 20,000, you're getting a lot of money orders. But yeah,
I had that where a guy brought cash and money orders, and since they maxed out at 500, I think he had to bring 12,000 or no 50,000 for that one. And
Yeah.
So there was a mix of cash and money orders.
yeah, and you've got 100 money orders at max, but it's not fun for us. Again, I want to make your client and I'm going to make you as the agent sit there while we count it all up.
And it was a scam.
No, sounds like it. All right, and then finally, if you represent the seller, same thing on a cash deal with a buyer. How we know that number early? A seller, we will know that number almost instantly. As soon as we get the commission amount and as soon as we get their payoff, if there is a payoff, we know exactly what the seller is receiving back from the closing. So if you represent the seller and you just want to give them an idea of what their final number is they're walking out with, you don't have to wait until the day before closing to bother the title company. Again, call them 2 weeks early and let them know. TRID does not cover the seller. So I know there's some title companies where they won't even send out a settlement statement to the seller. The first time the seller is looking at numbers is at the closing table. Title companies might not mean to do that. It might be the busy season and they've got to get these out to buyers because they know it'll kill the deal. They have to get it out 3 days before. We got to match CVs, and the seller kind of just gets pushed to the back end. So if you represent a seller, you're the listing agent, just let them know. Adam.
If I'm not mistaken, TRID only applies to primary and secondary residences, but if you're an investor,
Correct.
then it doesn't matter at all.
Correct. If you're an investor, and usually, and that's the very last form I have here is that HUD 1 form, and that's what will be used at the closing for investors. They're some people think they're more difficult to read. I think they're a little easier to read. They're breaking down pretty easy. But if TRID does not apply to the loan, like I said, that's when you really need to be on top of the title company with the closing fees and those final numbers, because the first time you see a settlement statement as an agent might be as you walk through the door 15 minutes before closing. All right, so final page, and this is, we've done all this stuff before the closing to make the closing go smooth, and now we're at the closing table. The first thing I always recommend an agent to ask for is a copy of the settlement statement. Print out the settlement statement that was sent to you 3 days prior or a week prior, whenever they sent it. Bring that with you to the closing and just compare it to the settlement statement you're being handed at the closing. If there's any differences or discrepancies, you can ask them, hey, why are these bottom numbers not matching up? And that way, again, you're not taken back by any or blindsided by any fees that were added last minute. Typically, if there is a change, it might just because, as Adam said, he wants to close on a Wednesday, but now they're closing on Thursday. This changes any kind of prorations that are involved. So the bottom number might change if the closing date changes, but just still bring that original settlement statement and ask the closing attorney, hey, why did these numbers change? And we'll be able to give you a straightforward answer. And if someone says, oh, it's because we decided to add, $1,000 in fees, say, hold up, don't tell your client not to sign anything, and just say, again, well, then here's the original. This is what we're walking out with. If you're holding a deposit check, this seems pretty simple. I know Jeff just told us about the new deposit, how we can ACH it and everything like that. We're still waiting on some final things on our end to get it all situated with our bank. But if you're a listing agent and you're holding the deposit, or if you're the buyer's agent and you're holding the deposit, please bring it to closing. We can't give you your commission check unless we have that deposit check. That's kind of our insurance to hold it, and we know Keller Williams, y'all are a great relationship with you. We know y'all are right down the street. We'll get that deposit from you. But a lot of new agents, again, just kind of forget. And not even new agents. We were at a closing last week. A guy who's been doing it for 20 years forgot to bring the deposit check. It happens.
That's
So-
why I just give you guys the check in the first place.
And then that's always easier. Like Adam said, just give it to the title company in the first place. That way it's on us. And
This could be a stupid question, but is it the exact same check that they gave us? That's never been deposited anywhere?
no, so if your buyer gives you the check, you'll give it, does Holly handle that?
Mhm.
Yes, you'll give it to Holly. Holly will put it in y'all's escrow account. And then I'm not sure when y'all cut them, but you'll just let Holly know, hey, we're going to close on the 8th at Oak Title, and she'll cut a check back either in Oak Title's name or she'll cut it in the buyer's name, and we'll just have the buyer endorse it at the table for us.
And it's important to know that stuff ahead of time, because like last weekend was a holiday. Ollie was out of town and Jeff was in Lake Charles helping people. And so all of the big signers were gone.
Right.
So you needed to get that done Thursday. So if you have a closing Friday and you forgot a check,
Right.
then it's up to me, the productivity coach, to forge the boss's name. And
And
I
I
just
just
want
want,
my risk appetite is that healthy.
and I just want to circle back to Adam's point about having the title company hold it. Take liability off yourself from holding the
Mhm.
deposit check. Inspections go terribly. Y'all want to file a cancellation, and both sides are arguing. No, we're past the cancellation inspection period. It ended yesterday at midnight, not today at midnight. And we want the deposit. No, we want the deposit. Let the title company decide who gets. And I'll tell you what, we're not going to decide if there's a discrepancy. We're going to go and bring it to the clerk of court and deposit it, and then let them fight over it and over there. But you just don't want that liability on you as well if something like that happens.
I've only been in real estate for 15 years and I've never held an escrow check, ever.
So it's
Always been the title company.
It's also easier on our end because when we reconcile for the cash to close number, we can say, okay, they've already brought this $5,000. We're not waiting on it. And the way our software works, we'll put a $5,000 deposit held by listing agent. And for whatever reason, our software says, oh, the listing agent already has $5,000. We're going to short them $5,000 on their commission. So it's just easy on our end, so we don't have to make all these mental notes and on the file and when we're printing checks. Finally, make sure the language that y'all agreed in the purchase agreement is reflective in the act of sale. So if y'all agree to as-is language, make sure that there is as-is language in that act of sale, that both the buyer and the seller are signing that as-is language in the sale. Make sure that if it's new construction, that there's new construction in the act of sale. Also, and I'll throw myself under the bus here. I did a closing where I had the cash sale had the wrong amount in it, but the CD had the closing disclosure had the correct amount. So the agent looked at the closing disclosure. I was like, yeah, this is all correct. But the cash sale, I think it was $425,000. I put $420,000 in there. When they went to go turn that into, you'll turn into LREC, correct? Or with the commission and the CD and everything. It got flagged and said, look, the CD doesn't match what's in the sale. What's going on? I had to file a active deposit. With the court, we got it all taken care of. But that's just something that you also want to just clarify that the purchase price in the actual physical cash sale looks correct.
If the sellers are giving $10,000 to the buyers at closing for closing costs and stuff like that, and the total amount doesn't equal 10,000, let's say it's 9,000 instead, do the buyers get that $1,000 or the sellers get that $1,000?
So that kind of just depends on whoever's doing the closing. Usually, if a bank sees it, a bank will, some banks I've seen will only apply the exact amount. So they agree to 10,000. They're like, okay, you get $8,231.06. That's all you're getting. And I've seen it to where some banks just keep it at 10,000 and they let it go. I think it's also on how you guys write it in the contract. If you write it specifically just for closing costs, they might only apply it for closing costs. I would always include prepaids. I would always include escrows, closing costs, and and then really if it's after that, this might be a question for Clayton on how he would want y'all to write it. But you can just say or reduction in the purchase price or something similar. But I would ask Clayton on how he would want you guys to handle that. All right, I'm going to quickly go over a couple forms that I made for you guys, just some mock forms that you'll be seeing at the closing table, just so you know what you're looking at. Do you need a copy of these, Adam?
And is that this?
Yeah, so we'll do this one first. This is our version of a settlement statement. And a lot of times, if you're just the listing agent, we'll just send you what the seller side is. If you're the buyer's agent, you might just see the buyer side. Look, just ask us if you want to make sure the commission is correct, and you want to make sure that there's this, a home warranty or anything that the seller's supposed to pay. Just call us, and we don't mind sharing that information with you, because you're going to get it anyway at the table. But yeah, this is what you'll get. 3 days before closing if TRID's involved. You'll get it sooner if it's a cash sale, or if you don't receive it and you're getting nervous and closing's a week away, call us. We'll make sure that everything looks good and send it out. But we'll just go over, say you represent the buyer. You'll see debits on the left side of the buyer column and credits on the right side. So debits is everything that the buyer has to pay for. This includes the sales price of the property. This is Orleans Parish, so he'll have to reimburse the seller for property taxes. If there's any insurance that was prorated to the date of the sale, that'll be on there. If insurance is not prorated, then you don't have to worry about that. But then you just have the loan charges, recording fees, and then title charges. And that's kind of where you want to look and just see if, okay, let me look at the title charges. That's where I want to see the quote. Remember, we received that quote, the estimate of fees in the beginning, and just see if that all kind of matches up. And just say, okay, they quoted us $180 on the abstract. It looks like it's $200. Okay, not that big of a deal. They quoted us $250 on a settlement fee. Oh my God, it's $450. No, we need to talk to them about that. And then finally, the credits on the right side. So that was the debits. The credits are going to include the deposit. What if there's if it's a finance sale, it'll have the loan, and then any seller credit. That's kind of all up there at the top. This little line kind of in the middle, that 341, that aggregate adjustment, that's only if there's a lender involved. I don't know how the lender comes up with this number, but basically they'll collect a couple months worth of fees in escrow at the beginning of the closing. They have a little formula that comes up and gives basically the buyer a credit back. And that's the aggregate adjustment. All right. And then finally, what we have on the second page at the very end are the totals. So you have, what's due from the buyer all the way at the end. And you'll see due from buyer, $71,968. And the way we got that is we just take that debit and minus the credit. So we take the debit, the left side, minus the credit from the right side, and then that's their cash to close number right there. Same thing for the seller. If you represent the seller, you look at their debits on the left side and their credits on the right side. So credits what's owed to them, their debits what they paid, which is their commissions, payoffs, and their closing fees. And you just minus the credit from the debit, and that 180, that's the number, that's the check they'll be getting back at closing.
Can you close virtually now that Corona's?
So no, because Louisiana, the question was, can we close virtually with coronavirus? Louisiana had the opportunity with the online notary, and they passed the online notary, and they've kind of muddied the water so much that it's still hard to do it. Technically, we always do what's called not act under private signature, but authentic act, which is in front of two witnesses and a notary. Technically, a sale does not need to be that. Neither does a mortgage. You just need to do it in front of a notary. An online notary would suffice for that. However, no bank is allowing that, and most title companies, just because of the liability, Louisiana kind of didn't they didn't give us a bright, black and white law on it. So no one is doing it there, but we took a small step in the right direction. I would not be surprised if in a year or two we're doing virtual closings. Some lenders are doing what's called hybrid closing, where you e-sign maybe 60 of your 100 pages before closing, and then anything that needs to be wet signed in front of a notary, that's all they're having you sign at the closing. So that's kind of where we are, is these hybrid type closings.
So it sounds like it's more dependent on the lender. Like, would you personally, if the lender was okay with it, would you?
If the lender is okay with it, we have a program that would allow for it. The problem with is, again, Louisiana made it so difficult. We have to send you a text with a code on it. You got to call us, tell us what that code was. You have to provide witnesses. You have to have a camera like this in the room, showing the whole room that you're not under any undue influence. They kind of made it very difficult for someone who, doesn't have the technology to do it. But, we've gotten creative with coronavirus, whether it's a drive-through closing, mobile closings, things like that.
So you need a camera?
Yeah, and I'll look up the legislation that was passed on everything that's required. You'll still need 2 witnesses to be there with you. You'll still need it's a double authentication. So not only do we need a copy of your license, but also that code, like we text you the code, call back, make sure that it's you. Everything has to be recorded and stored, and then it's also kind of up to the clerk of court as well. John Bell Edwards did pass that executive order in the beginning allowing e-sign notaries to be recorded. I think has not been. I don't think he extended it yet. He extended it a couple of times. I don't think he extended it again. So a lot of clerk of courts will not accept the e-signed. They want a wet signature with blue ink to be recorded. So we're working on it. I know a lot of people are trying to pass legislation. Like I said, we're probably a year or 2 away from it.
Yeah.
Hopefully sooner. Was it this past June, I think, when they met? I think they dropped the ball on it a little bit. They just made it too convoluted a little. All right. Yeah. The next document that I have for you guys is the buyer's. This is the buyer's closing disclosure. This is what needs to be sent out 3 days beforehand and signed by your buyer to satisfy TRID. It's weird on who, because it has interest rate and your loan, interest rate and some personal information. It's kind of unclear who can actually see this. That's why we came up with the settlement statement, why title companies have come up with settlement statements, to still show you the meat of everything and the actual numbers. It kind of just takes away what their monthly principal and interest is, what their interest rate, and what their escrows are. But yeah, on the second page of this document, it's the exact same thing that we just went over on the settlement statement. It's just a breakdown of, again, the different fees that you have broken down, and then how much each, the name of the fee and how much each of those fees are. If you do get a copy of this closing disclosure, some people think it's easier to read than the settlement statement. What you want to look at is section C. You want to look at section E, and then you want to look at H for the owner's title insurance. And that's kind of what we quote out, are those 3 sections. And so if you're trying to compare the quote on, make sure everything lines up with what was given to you a month ago, those are the 3 sections you want to take a look at. And then on page 3, it's similar to page 2, that last little section of the settlement statement. They break it down, I think, a little easier, up and down instead of side to side. They just have what's owed by the or due from the borrower, and what is going to be already paid on the borrower's behalf. And they just take that top bold number minus by that bottom bold number, and you get that 71,968 number again. And that's the cash to close number. That's what they'll be responsible for bringing to the table. But I'll upload this for you guys. I'll send it over to Adam. For the most part, you probably won't be seeing these documents. You'll probably be seeing the settlement statement. But it's always good to know how to read one of these documents, especially if you get a call from your buyer who says, hey, look, they just sent me over the closing disclosure. I'm going to send it to you. I have some questions. At least you can kind of tell them exactly what is on there. One thing I did not talk about, get into, is prorated taxes. Depending on what parish you close in, your taxes are either paid in the beginning of the year for that upcoming year, or at the end of the year for the current year. So Orleans Parish, all taxes for 2020 were paid in January. And then every other parish in the state, all taxes for 2020 will be paid in December. So if you represent a buyer and it's an Orleans Parish, he will be paying for taxes, reimbursing the seller for taxes they've already paid, starting from the date of the closing to the end of the year. A lot of people always ask, why am I responsible for paying taxes? I haven't lived in the property all year. And you just explain to them it's prorated. It's from the date of the closing to the end of the year, from when they actually will own the property. Jefferson Parish, if you represent the buyer, you will likely be receiving a credit instead of paying. So same thing, if you represent the seller, they'll see that they are paying taxes from the beginning of the year until the date of the sale, and they're just reimbursing the buyer, who will be responsible for the full tax bill at the end of the year. Taxes generally confuse a lot of people, but if you just explain just how I said it to them, look, you're only going to be responsible from the days you live in the property or own the property, they generally have a little more understanding. If you want to know how we prorated the taxes, and what number we're using, just call the title company. You can say, look, the property is only assessed at this amount. Why are the prorated taxes seem so much higher? And they can give you an answer, whether it's what we called the parish, and the parish had reassessed for this year, so we have to go by the new assessment amount. Or if it's before May 31st, that's usually when assessments are due. The new purchase price may affect the taxes for the end of the year. All right, the next document, same thing. This is a closing disclosure, and it's going to be for the seller. So this will only have the seller's fees on here. We give these to listing agents all the time. This, again, is not governed by that TRID rule. So we have no problem sharing it. We'll give the seller, the listing agent, the settlement statement. If they rather see the closing disclosure, we have no problem handing that over. And it's the same thing as the buyers. Again, a little easier to read. You have what's due to the seller, what's owed by the seller, and then that bottom number is going to be what's their check will be at the closing, how much they are taking from the sale. On page 2, let me back up. Page 1, you'll see in section N, due from seller, line 2, closing costs paid, and it's that $21,000 number. That number there is broken down on page 2 for you. So page 2 for that $21,145, it's broken down, and you can see exactly where that is. Majority of it is the buyers and the listing agent commission. And then there's, we had that home warranty that they agreed to pay. City of New Orleans, it's important to know that if you represent the seller, they will be responsible for a $325 dock tax. The city, just every transaction, anytime a document is filed affecting title on a property, the city charges that $325 dock tax. And then section C would just be their portion of the closing costs. It's pretty easy, pretty straightforward, very simple to read. But again, if you have a question, or if you're kind of looking at it and you're getting lost or flustered, call the closing attorney or the title company on the phone and just say, hey, I have the closing disclosure in front of me. Can we just go over each of these fees and how we're getting this number? All right, and the very last document, this is a HUD-1 document. And Adam had mentioned earlier about a sale that did not qualify for TRID. And so these are cash sales. If an LLC is buying a property, typically, they have a different type of loan, or if it's a loan that doesn't need to follow TRID, we will use, and the banks will use this form of settlement statement. And again, it's pretty straightforward, like the seller CD we just went over. On the left side, you have the borrower or the buyer's information, and on the right side is the seller. And we'll just go left side. You have, what's due from the buyer. They give you on line 120 that gross amount due, and then what's already paid on the buyer's behalf. 220 gives you that gross line. You just minus 120 from 220, and it gives you that total on line 303. Seller, same thing. It's what's due to the seller, and they'll give you that total on 420, and then what's owed by the seller, and that total will be on 520. You just subtract 420 from 520, you get line 603, and that's the cash that they'll be receiving at the closing table. Page 2 is just a breakdown of the closing costs. Again, left side is going to be buyer, right side is going to be seller, and I'm sorry, again, keep going back on page 1. You'll see closing costs on line 103 for the buyer, and line, let's see, where is it for the seller? 502 for the seller. And this is just a breakdown of those numbers there on page 2. So at the closing table, you want to be familiar with all of these forms. Know what kind, if you're looking at a settlement statement, a HUD-1, or a closing disclosure. Just get familiar with them, know what you're looking at. So when you go into the closing, and again, if you have an escrow agreement, are the 2 documents you really want to see at first, just to make sure everything looks good. And this way, you know exactly what you're looking for. You're not just looking, oh, wow, I made $10,000 on a commission. This is great. You have your client's best interest in mind with these. Look, if y'all have any questions at all, throughout this whole process, please, reach out to myself or Alita Carroll, who's the other attorney in our office. Be happy to go, more in depth on these things, more one-on-one with you guys. We do it all the time. So, don't ever hesitate to pick up the phone and give myself or the office a call. Hope you guys enjoyed it. Hope you guys learned some things or were refreshed on a couple things. If you have any confusion on it, I know it's kind of hard when you don't have the material in front of you. Again, just give me a call and I'll go over it with you more in detail there. So thank you.
I don't have to go take the call. I'm not sure how to close all of them. Set a coaching call, so I don't know. Thank you for doing this.
No worries.
I haven't gone through closing yet, but I just put my first offer on a house with a buyer.
All right, perfect. Well,